All right, our second case this afternoon is case number 24-1331, Spirit Human Resources et al. Versus Johnson. Ms. Connor?
May it please the court. My name is Jessica Connor, and I represent the employer carrier Spirit Human Resources LLC and CCMSI. At counsel table, I have my co-counsel, who is trial counsel in the case, Mr. Brian Lowe. If I may, I would like to reserve 5 minutes for rebuttal.
Noted, thank you.
I must begin by emphasizing the JCC's factual finding on page 16 of the record that the claimant was diagnosed with his psychiatric conditions before he voluntarily dismissed his first petition. This factual finding is entirely dispositive of whether a new condition, and hence a new claim, arose after claimant's voluntary dismissals to allow the claimant to circumvent the application of the two-dismissal rule and res judicata. On page 16 of the record, the JCC found that before the first dismissal, Dr. Hoffen, the neurologist, diagnosed claimant with, quote, post-traumatic anxiety mood disorder, and he treated the claimant for that psychiatric condition with escitalopram, which is the generic Lexapro medication, which is an anti-anxiety, antidepressant medication. So the claimant was both diagnosed with and treating for mood disorders before the first dismissal. It was not a new condition that arose after the first dismissal. And Dr. Hoffen, the neurologist, placed him under work restrictions: light duty, no heavy lifting, avoid warehouses or factories, no driving of commercial vehicles. And the claimant testified at the final hearing that the reason he could not work was because of his psychiatric conditions.
Doesn't it matter that the first doctor, Dr. Hoffen, also referred him on for a neuropsychological evaluation, that he was in some sense recognizing the limitations on what he was able to speak to, and so he was referring him on for other medical consult?
Yes, he did refer him on to a neuropsychologist. He also referred him to the psychiatrist, but to continue getting further evaluations and further treatment. But the important point, the dispositive point, is that he did diagnose the claimant with the condition that he claimed was a new condition, and that the JCC treated as if it was a new condition simply because he went to the psychiatrist after he dismissed the first petition. But he knew before he dismissed the first petition that he was suffering from these psychiatric conditions. He knew he'd been diagnosed for them, and he knew that he was receiving treatment, medications for them. And he testified very clearly at the final hearing that it wasn't his concussion or some physical injury or neck pain or something else that was keeping him from working. He specifically said the reason why I could not return to the warehouse is because he would have flashbacks to the work incident. And he said that that really weighed on him mentally. It caused him psychological distress. Every time he thought about going back to his job at the warehouse, it was causing him great anxiety, and he testified to that. So what you have here is a claimant who knows he's suffering from anxiety, knows he has a psychiatric condition, and yet instead of going on to get further additional treatment and the opinions of the psychiatrist that he was referred to, he voluntarily dismissed his claim, then refiled and tried to argue it was a new claim simply because he had not treated yet with the psychiatrist before he dismissed.
So you would distinguish this case from, say, Marino, where there was also three evaluations, that there it seemed to be that the first two were physical, back-related, and the third was psych-related. And you would say that all three of yours were psych-related, that it was the same claim.
Exactly, Your Honor. In Moreno, this court specifically said that the current claim under the third petition, quote, came into existence only after both claims were dismissed. So that is, he had a back injury, but he was not diagnosed, the claimant in Moreno was not diagnosed with the psychiatric condition until after the first two dismissals. And so he didn't know. In that situation, the condition was evolving and changing, and it changed after he dismissed, such that he didn't know he would have the psychiatric condition. but that's completely distinguishable from the facts of this case. It's also distinguishable from the Thomas versus Eckert drugs case, and that's the case from this court in 2008, where the claimant's back pain from a work injury was originally attributed to her pre-existing fibromyalgia. And so she dismissed her lumbar claim because the doctors were saying, no, this isn't work-related, this is fibromyalgia. Years later, new medical evidence first established the work connection to her back pain. So she refiled her claim at that time, and this court held claimant's petition for benefits was not barred by res judicata because although she knew she had lumbar pain at the time of the first hearing, she had no medical evidence then to indicate a compensable claim. And that is the exact opposite of what we had here. We had 3 doctors, all of them talking about this claimant's anxiety, his depression, his PTSD, all of these things, and not a single one of those doctors ever said this is pre-existing, and in fact, the neurologist put multiple times in his medical records that these psychiatric conditions were, or he stated there were no pre-existing mood disorders, no known psychiatric conditions before the work accident. He explained that the anxiety and depression was getting worse since the accident. He explained that the Lexapro was helping. He just felt that he had done everything he could for this claimant by giving him the antidepressants. He wanted him to see a psychiatrist so that he could manage his psychiatric conditions and get things like counseling and talk therapy. But just because there's always some other specialist that a claimant could potentially go see doesn't make it a new claim to get around res judicata simply because after you dismiss, you go see another specialist. Imagine if he decided he wanted to go get an IME after he dismissed. Well, going to see an IME psychiatrist was available to him before he dismissed. All of the evidence he needed to bolster his claim that he could not work was available to him if he had simply gone and gotten it instead of dismissing his claim the first time. Now, it's
So at least one of these dismissals that are at issue seems to be by agreement. They agreed to dismiss without prejudice so they could go to mediation. What's the effect of that?
Your Honor, the JCC below made a factual finding that trial counsel for the EC made no such agreement. She put it in her appendix to the final order where she specifically addressed this argument that there was an agreement that the dismissal could be without prejudice. And it's on pages 28 to 29 of the record. She said, I reviewed the emails. I find the emails were mentioned in argument. Claimant had posited his understanding was that the parties had an agreement not to pursue the 2 dismissal rule in discussing the voluntary dismissal of the 12/14/2022 petition. Mr. Lowe, trial counsel, denied any such agreement. And then she said, the email referenced actually requests an agreement that the EC not move to tax costs on dismissal of the petition. So she made a finding that was adverse to the claimant. And if the claimant, as the appellee, wanted to ask this court to reverse that adverse finding, it was incumbent upon the claimant to file a notice of cross appeal. They're trying to rely on the Tipsy-Coachman doctrine. Everybody knows that Tipsy-Coachman is the appellee's best friend, but that friendship has to be supported by the record, and it is not supported by the record here when the JCC made a factual finding the exact opposite of the claim that there was an agreement that the second dismissal could be without prejudice. And so therefore, they cannot ask this court to reverse that factual finding without filing cross appeal. There was no cross appeal in this case. And there's certainly, even if there had been a cross appeal, there's certainly competent substantial evidence in the record to support the JCC's finding that Mr. Lowe made no such agreement based on the emails and based on what he represented at a pretrial hearing, which was part of the reason why she said there was no such agreement. She read the emails, but she also heard the representations of counsel. Both of the attorneys who were the parties to those emails were argued at a pretrial hearing about the emails, and they both provided representations as to what they meant by those emails, and she found there was no meeting of the mind. There simply was no agreement that this dismissal would not be subject to the 2 dismissal rule or res judicata. So the claimant just simply chose to dismiss the first time. then proceeded to his appointment with the psychiatrist, then proceeded to depose the psychiatrist, obtain the additional opinions from the psychiatrist about his inability to work, and then rather than proceed to a final hearing, again inexplicably dismissed the second petition when he had all of the evidence at that point to prove that he had a psychiatric condition preventing his ability to work, and therefore res judicata and the two dismissal rule certainly should have applied, and it was error to hold that it didn't apply.
Is the challenge for us somewhat fact-based in that the first PFB was based upon, there was a head trauma at work, and it was based on a post-concussion type syndrome a theory where the doctor diagnosed the concussion, said further cognitive evaluation is needed, and by the time you get to the third PFB, you're talking about TBI and a mental disorder. That there's some continuum there between, okay, this is a concussion that needs treatment versus where we get to with the third PFB, and at some point, hypothetically, there's a break between, okay, what was looked at first and what formed the nature of the first PFB is different from what we're getting at in the third PFB, and that's somewhat of a factual type inquiry.
So I think it's not a factual inquiry because where the JCC went wrong was looking at the facts and evidence at the time the petition was filed, where the case law says, for purposes of res judicata and figuring out if it's the same claim being relitigated, we look at the facts and evidence as they existed at the time of the adjudication or the dismissal. So just because a petition starts off and says, as of the date I filed this petition, I'm relying on Dr. So-and-so who says he diagnosed me with a concussion, the petition is seeking indemnity from that date forward and continuing. So throughout the life of that petition, before you get to a final hearing, he's continuing to treat. He's continuing to not be able to work. It started off with the first doctor saying he can't work because of a concussion or maybe a cognitive issue. But before he gets to the final hearing, he's now treated with that same neurologist who's now saying, okay, it's not just a concussion. He changed the diagnosis to depression, anxiety, PTSD. The neurologist diagnoses him with that before he dismisses the first time. So now the evidence has evolved to support why he can't work. It's multiple things: a concussion, cognitive problems, psychiatric issues. The point is he knows all of this before he gets to trial, and he has all of the evidence and he has the availability of all those medical records to say the reason I couldn't work, it was concussion, it was neck pain, it was cognitive issues, and it was psychiatric. He would never have gone to that final hearing, and the JCC never would have said, well, you didn't put in your petition that you were going to rely on psychiatric conditions as well. No, he would have said, well, that's why it was and continuing, because it evolved during the life of my petition. And the case law, this court says, we look at what was the facts, was the evidence that was available to the claimant at the time of the final adjudication, or the time that he voluntarily dismisses, if we're talking about two dismissal rule. And if all the facts and the evidence were there for him to have a ripe claim, a claim that's ripe for adjudication, he must bring all of those claims for damages based on whatever evidence he has on all of the different doctors for all of the different conditions that he knows of as of the time of the final hearing. And if he felt that he couldn't properly prove his claims without the additional testimony of the psychiatrist, and the appointment was after the final hearing, all he had to do was go to the JCC and say, the EC dragged their feet in getting me this appointment with the psychiatrist. I think the opinions of this psychiatrist will bolster what my neurologist said about me not being able to work. It will bolster what my neurologist already said about me having psychiatric conditions, and I want further testimony for this final hearing, so please continue the final hearing until after I see my psychiatrist. Or he could have gone and gotten an IME. He could have gotten his own psychiatrist if he thought that was necessary to bolster his claims at the final hearing.
When is it different enough? Where do we draw that line? It does seem that we have some largely factual issues at play that require some resolution. Every claim is going to have at least some slightly different circumstances. The time period may be different. You might have some different symptoms, things like that. Where do we draw the line on how different does it have to be?
Well, the cases speak in terms of that the causes of action must be, quote, substantially the same. They don't have to be identical. They just have to be substantially the same. So you can't make what this court, this is not my, or what the third DCA at least has called, you can't by simple expedient of filing an otherwise identical lawsuit seeking $1 more than that involved in a prior suit and claim it's a new case. And I think that's what happened here, is that they just tweaked the start date for the indemnity benefits they were seeking by a day, or in one petition by a couple of weeks. And
But
so,
isn't there inevitably going to be some factual determination that the JCC is going to have to wade into that and figure out, okay, well, where do we land in that scale? Some fact finding that has to take place there.
certainly, and I think in another case, maybe that would be difficult to draw that line, but I think in this case, it's so easy because the JCC herself put in her final order that the claimant was diagnosed with these psychiatric conditions before the first dismissal. So he knew the reason he couldn't work was the psychiatric conditions and chose to dismiss. It's very easy here. The only reason why I think the JCC, erred is not because of a factual finding. We agree with her factual findings. It was a misapplication of law to fact. It was she looked at the fact that when the first petition was filed, he hadn't treated with the psychiatrist yet. And so she said, well, now that's new treatment, now he can claim that's a new condition, but it's not a new condition if the condition was always there and he knew it was there and he'd already been diagnosed before he chose to dismiss, because a claimant could always, let's say he intentionally refused to go see the psychiatrist, just so if he loses at a final hearing, he can then refile, go see the psychiatrist and say, aha, new evidence, because the psychiatrist's opinions did not exist at the time I dismissed before. They didn't exist, but they were always available, and that's what matters for res judicata in the two dismissal rule. It's not whether I have the deposition transcript in my hand. It's, could you have gone and deposed this person? Could you have gone and seen this person? Did you know about the evidence and you simply failed to take advantage of it and go get it? That's what happened here. The claimant had everything he needed to know about why he couldn't work and what he needed to prove his claim. He chose to voluntarily dismiss. And I see that I'm into my rebuttal time.
Yes, you may continue or you may save your time.
I would like to save my time, thank you.
Mr. Skolko.
Yes, good afternoon, Your Honors, Ms. Connor, and may it please the Court. Tom Skolko here on behalf of the appellee, Kenneth Johnson. With me at counsel table is Mr. Johnson's trial counsel, Sean McCormick. Now, we've set forth several reasons why the JCC's order should be affirmed, but first and foremost is that the JCC correctly applied this court's decision in Moreno versus Palm Beach County School Board in finding that there was no identity of cause of action between any of Mr. Johnson's three petitions. The employer carrier argue that the only thing that matters for the application of res judicata based on the two dismissal rule is whether the evidence supporting the last filed petition existed when the second petition was dismissed.
Well, she even says the first petition was dismissed.
Well,
Everything was known when the first petition was dismissed.
Well, I don't see what difference the first petition would make. That's what's a little confusing to me, because their argument in their brief was all about the second petition, and now I hear about the first petition. But dismissal of the first petition doesn't have any legal effect whatsoever because a claimant gets two, right? So what difference does it make what the evidence was at the time of the first petition? Rather, the argument that they were making throughout the entire brief is that the evidence that formed the basis of the last petition filed existed when the second petition was dismissed. But that argument assumes the very thing that the employer carrier was required to prove, which is that there was identity of cause of action between all three of the petitions. Because if there's no identity of cause of action between the first petition and the second petition, then the dismissal of the second petition isn't a second dismissal under the two dismissal rule.
Well, I think that's what she's saying. At the time that the first was dismissed, everything was known. So when the second was filed, the same everything was known. And when the third was filed, the same everything was known. And so with all three petitions, you had the same evidence.
Well, absolutely, that's absolutely not what the JCC found. The JCC found that each of Mr. Johnson's three petitions was premised on different basis, different facts. The first petition the JCC found was premised on a no commercial driving restriction signed by the neurologist, Dr. Hoffman. The second petition was premised, according to the JCC's findings, on neuropsychological deficits and an opinion by a different doctor, a neuropsychologist, that Mr. Johnson couldn't work until certain therapy had been done. And the third petition the JCC found was premised on completely different evidence than the first two, which was that a psychiatric opinion from an authorized treating psychiatrist that Mr. Johnson was disabled from working during that period. But I want to go back to the identity of cause of action issue, because I think that's really controlling to this case. If there's no identity of cause of action between the first and second petitions, then the second petition, the dismissal of the second petition, isn't a second dismissal under the rule. And without a second dismissal, there's no adjudication by operation of the rule. And therefore, it doesn't matter if there's no adjudication by operation of the rule, then it doesn't make any difference what the evidence was at the time of the second dismissal. And so what's the test for determining identity of cause of action between petitions? It's exactly what this court said it was in Moreno, that the facts integral to the last filed petition must be the same as the facts integral to each of the previously filed petitions. And that's the same test that other district courts of appeal have applied to determining identity of cause of action in the two dismissal rule in the civil context.
There's something different, right, between just seeing a different doctor and you could imagine a scenario where there's a claimant sees multiple doctors and gets maybe slightly different results from these different doctors, but the underlying issue is all the same, right? And so how do you distinguish this from that kind of scenario where you really have the same core issue? And yes, there are slightly different time periods. Yes, there's some different doctors involved, but ultimately it all goes back to the same issue.
Well, again, ultimately it goes back to the same injury, but the evidence which would support the first petition was entirely different than the evidence that would have supported the second petition, which was entirely different than the evidence that would have supported the last petition. Different doctors, different opinions for literally different diagnoses. But
so does going to see a new doctor allow you to escape the rule?
if you get a new diagnosis and a different opinion, it might allow you to escape the rule. And in fact, that's exactly what this court indicated in the Prada case that said that res judicata, while it has its place in the workers' compensation arena, has to be applied with great caution because workers' compensation cases involve, just like this case, constantly evolving medical changes to the condition, which is exactly what happened here. But I want to point out, even more importantly than that, the employer carrier says they're not challenging the judge's factual findings. The judge found as a fact that each of the three petitions were based on different evidence. That means you have to accept that finding for purposes of this appeal, and applying the test set forth in Moreno, that finding precludes identity of cause of action between any of the petitions. Even if you think maybe it was wrong, the judge made that finding and they haven't challenged it on appeal. Their whole argument is that the only thing that matters is the state of the evidence when the second petition was dismissed. But that assumes that the dismissal of the second petition was a second dismissal of the same cause of action, which is the very thing that they have to prove. Here, there was no identity of cause of action between any of the three petitions based on the JCC's findings, which were not challenged by the EC in this appeal. And consequently, the order we contend, must be affirmed on that basis alone. But I'd also want to address the other arguments that we made for affirmance based on the Tipsy-Coachman doctrine. One that wasn't discussed was our argument for affirmance based on the invalidity of the two-dismissal rule itself. The employer carrier argues that under this court's decision in Willett, that in order for this court to be able to look at the invalidity of an administrative rule as a basis for decision, that rule must conflict with the enabling statute. We agree. But what the employer carrier's argument misses is that a rule that enlarges, modifies, or expands the enabling statute beyond the text of the statute is what it means to conflict. And that was specifically addressed by this court in the LG decision. In LG, this court cited a federal decision with approval that held that an administrative rule that expanded the scope of its enacting statute necessarily contravened that statute. That's what the two-dismissal rule does here.
So the statute here says that, that rules must, it gives rulemaking authority and says the rules must include procedural rules applicable to a workers' claim resolution. Why isn't this just a procedural rule that, hey, at some point, this rope-a-dope, filing a claim, dismissing, file, dismiss, file, dismiss, file, dismiss, why isn't this in the nature of simply a rule, a procedural rule applicable to getting claims resolved?
Well, in order to be a valid rule, it has to, one, has to have general rulemaking authority, which is I think what you're talking about in 440-45 sub 1, that gave DOA general rulemaking authority to enact procedural rules. But the constitutional case law requires more than general rulemaking authority. It requires specific statutory authority for a particular rule. And in this case, the four statutes that DOA cited as providing authority for the rule, they have nothing to do with the two-dismissal rule. 440-25, 440-29-4, 440-33-1, and 440-45-1, none of them say anything whatsoever about treating a second dismissal as an adjudication of denial on the
And
merits.
so your argument is that the legislature would have actually had to say two dismissals equal
Exactly.
barred, and it couldn't have said something more general like you have rulemaking authority to put together a regime that gets cases resolved.
Well, the case law requires specific statutory authority, and there is no statute that specifically authorizes this. I think what happened, and this is just my speculation, is that the Supreme Court used to promulgate rules of procedure for workers' compensation claims in 2004, and one of those rules was the two-dismissal rule. In 2004, the Supreme Court decided that they had no constitutional authority to promulgate rules of procedure for an executive branch agency and directed DOA to do so, and DOA dutifully did so. And one of the things they did was they just brought over, word for word, the two-dismissal rule that was in the previous Supreme Court rules. But I think what they overlooked is that the Supreme Court's authority to enact rules for the judicial branch stems from their constitutional power over the judicial branch, and they don't need statutory authority for any particular rules. But an executive branch rulemaking does need that specific statutory authority. And we contend there plainly is none. That means it necessarily modifies, enlarges, or contravenes the enabling statutes and is therefore invalid, and therefore cannot form a basis for reversal of the JCC's order here.
Even though the Supreme Court came up with it.
Well, but they did.
Yeah.
But they did it in the context when they thought they were making judicial branch rules. Now, I also want to address the email exchange between counsel for Mr. Johnson and trial counsel for the employer carrier. Counsel for the EC argues that there was some sort of adverse finding regarding that email exchange. That's not true at all. What the JCC did in a footnote to the order indicated why she was going to allow that email exchange into evidence. There was no finding as to the impact of that email exchange on the substantive issues in the case or the defenses. But regardless, an appellee has no obligation to to cross-appeal a fully favorable judgment. This judgment below was fully favorable to Mr. Johnson. He had no obligation to cross-appeal anything about that, and in fact, the only finding that the JCC made was the JCC allowed it into evidence, which we agree with. And also, the plain text of the rule, of the email exchange, makes clear how unfair it would have been to apply res judicata here. The email exchange between the counsel for the EC, I think, said, hey, why don't you voluntarily dismiss your petition and we can set it for private mediation? Mr. McCormick responded, okay, but will you agree that you won't see costs as a result of the dismissal and that the dismissal will be without prejudice? And the EC's response was, all sounds good. What interpretation could there possibly be other than the EC was agreeing that Mr. McCormick could dismiss the petition without prejudice? Without prejudice means, by definition, that it's not a second dismissal for purposes of res judicata. And it doesn't matter. They say that, Ms. Connor points out that the judge didn't determine what the email exchange meant or that there was an agreement. It doesn't matter whether there's an agreement. All that matters is how a reasonable person in the shoes of Mr. McCormick would treat that email exchange. Mr. McCormick dismissed that petition the very next day after that email exchange. For the EC to suggest that the dismissal was inexplicable, it's contrary to the plain record and common sense. The email exchange speaks for itself. It establishes the gross unfairness that res judicata would have applied here. And for all these reasons, we submit the JCC's order awarding TPD benefits, penalties, interest, costs, and attorney's fees should be affirmed. And if the court has no further questions, I'll yield back the balance of my time.
Thank you, Mr. Skolko.
Thank you.
Ms. Connor?
Thank you, Your Honor. The two dismissal rule is not invalid, and it's not an improper delegation of legislative authority. The statutory authority for DOA to make the 60Q rule of procedure comes from section 440.45, which says that DOA shall have the authority to make procedural rules applicable to workers' compensation claims. And the 60Q rule is just that. It's a procedural rule that explains that by operation of law, when you have a second voluntary dismissal, that is an adjudication on the merits. But the consequences of a second voluntary dismissal being an adjudication on the merits comes from the common law doctrine of res judicata. So all the 60Q rule does is set forth that procedural issue that it's a voluntary dismissal is a final adjudication, but then DOA didn't then circumvent the legislative authority to make substantive defenses. The res judicata still comes from the common law. So when we say two dismissal rule, we're really talking about two things. We're talking about the 60Q rule, and if we were in the circuit courts, the Florida Rules of Civil Procedure have the exact same two dismissal rule. It's in Rule 1.420. It says the exact same thing. The Florida Supreme Court has been delegated the authority to make rules of civil procedure, and the Florida Supreme Court enacted the two dismissal rule for civil litigation. It's the exact same rule under the 60Q rules of procedure. Nobody's ever challenged the Florida Supreme Court's ability to make the two dismissal rule, because again, when we say two dismissal rule, we're really talking about both the procedural aspect and the common law doctrine of res judicata, which are the consequences of having a final adjudication is that you may not relitigate the same claim again. And if they wanted to challenge the two dismissal rule, the 60Q rule, they were required to file an administrative proceeding in the lower court. This court is a court of review. It does not decide factual issues in the first instance. It would not decide to invalidate a rule, a DOA rule, without having a lower tribunal first allow DOA to intervene to defend its rule, which is what the case law says should be done. So it's just not proper to ask this court for the first time in an answer brief to invalidate a 60Q rule. And to get back to, I heard my friend concede that seeing a new doctor could make a difference for res judicata if the new doctor gave the claimant a new diagnosis. But again, the psychiatrist in this case did not give a new diagnosis. It was the same diagnosis that the claimant had already been diagnosed with since before he chose to dismiss the first time. And for those reasons, we would request that this court reverse and remand for entry of final judgment in favor of the EC. Thank you.
Thank you, counsel, and thank both of you for your helpful arguments. That concludes our oral argument session for this afternoon. We're adjourned.